And to bring us into the area of investment treaties, we have Lauge Poulsen to talk about some of the politics of investment treaties and smaller states. Lauge.
I think I'll just stand up here so I can use the slides. That's okay. Yet another smooth transition. Well done. Can we open it?
Happy to be here.
Okay. So I am not a lawyer, yet have nevertheless been invited to the panel today, right or wrong, because I have spent the last 6 to 7 years of my life trying to understand how developing countries in particular signed up to investment treaty obligations over the last couple of decades. And that was just published in a book, some of which I'm going to go through today because it has relevance to today's discussion. Now, in the little package we got here, there's an ad for a book by Petra Butler and Caroline Morris called The World of Small States, where in the little text of the book it says that small states allow us to study and gain insight into the challenges of big states, which is true. The opposite is also true. I'm going to do the opposite because most of my work has been focusing on large developing countries and how they came to negotiate and adopt investment treaty obligations. And I think some of the lessons from their experiences apply very much so also to small states. As a starting point, let's have a look at the big picture here. So this list of small states doesn't exactly qualify under the definition used for this conference. I just used the World Bank's list of small states on its website. And then we have the number of BITs signed and ratified if they're red, signed but not ratified if they are blue. And we can see from about more than 40 BITs signed by Mauritius down to only 1 or 2 by countries like Bahamas, Marshall Islands, and so forth. There's a wide variety of investment treaty networks amongst small developing countries. But the vast majority have signed up to at least a couple of investment treaties. And most of these have also ratified at least a couple of investment treaties. The little stars after the names of the countries is when there has been a claim under one of these treaties against one of these states. That does not necessarily imply that the state in question lost the claim, but it has been subject to one or more claims if there's a little mark. And we can see that almost half of the small states on the list have been subject to investment treaty arbitration, where investors, multinational corporations, or other sources of foreign investment have filed claims against these states on the basis of the consent to investment treaty arbitration enshrined in their agreements. Now, as Jansen sort of alluded to, much of investment treaty arbitration, at least over the last 10 years or so, has not been as happy as an experience as Stephen Fietta mentioned in terms of interstate dispute settlement. There's been much frustration about the costs, the occasional inconsistent rulings, and occasionally on some of the awards that's been ruled against states, there's been a discontent about the nature of the regime in many different respects, which raises a couple of questions. Now, I'm not going to go into sort of a cost-benefit discussion of whether or not it's a good idea to sign up to these agreements in the first place. That's an interesting debate, but I don't think it's one that's appropriate for the discussion today. Rather, what I'm going to focus on is how. So how did governments in many developing countries, including small states, sign up to these agreements? And that, to many, at least outside of arbitration circles, is a puzzle. It is a puzzle because it is inherently surprising that governments would want to constrain their regulatory autonomy to such an extent, would want to expose themselves to often expensive arbitration claims and delegate quite significant powers to often private lawyers who act as arbitrators. So whether or not one thinks that a government should sign up to investment treaties, it is nevertheless an interesting question how they actually came to sign up to these obligations in the first place. How were they actually negotiated? And in particular, was there an appreciation always of the nature of the agreements and the potential liabilities that could result from them? And as a starting point, let me start with an anecdote. So this is again not a small developing state, but a large developing state. the case of Pakistan. And for those of you who are very familiar with the investment treaty regime, you probably heard this anecdote before, so I apologize. But for those of you who are not, let me just repeat it here. In 2001, Pakistan was subject to an investment treaty claim by a Swiss investor called SGS. And there were some news stories about this claim in various fora that caught my interest. This was the beginning of my project many years ago. So I decided to go to Karachi to discuss this claim with the then Attorney General of Pakistan called Makhdoom Khan, who was one of the most knowledgeable experts in international public law, knowledgeable experts in international commercial law in the region and still is today. And he had an interesting story to tell. So he said that in 2001, when he was Attorney General, he received a phone call from the then law minister, Umar Bandial, who later joined the Supreme Court of Pakistan. And the law minister said that he'd received this letter from Washington, from this thing called the International Center for the Settlement of Investment Disputes. And in the letter it said that Pakistan was being sued by a private investor called SGS. But Pakistan was not being sued in Pakistani courts, not being sued in American courts, despite the fact that the letter came from the United States. It was not being sued in Swiss courts, despite the fact that it was a Swiss investor. It was being sued under this thing called ICSID, under the World Bank. And it was being sued not on the basis of the contract between SGS and the Pakistani government. It was not being sued on the basis of Pakistani law, Swiss law, or indeed US law. It was being sued on the basis of a bilateral investment treaty that had been adopted between Switzerland and Pakistan in the 1990s. Umar Bandial, the law minister, asked his Attorney General, do you have any clue what any of this means? Do you know what ICSID is? Because I've never heard of it. And what is this thing called a bilateral investment treaty? I've never heard of those things, but it says here that apparently we've signed up to it. And Makhdoom, one of the most knowledgeable experts on international public law in the region, he was very embarrassed. He said, I'm sorry, sir, I have to get back to you. So he hung up the phone, and then he went into Google, and I kid you not, he pressed, what is a bilateral investment treaty, and what is ICSID? And that's how he learned about those instruments for the first time. And I later confirmed it through archival work in Islamabad over a couple of years and interviews with many officials. And the reason Makhdoom Ali Khan had never heard about these instruments before, despite the fact that Pakistan had been negotiating them for decades, and in fact was the first country to ever sign a bilateral investment treaty with Germany in 1959, was because, at least in the case of Pakistan, these agreements were never really negotiated. When Pakistani leaders went abroad, or there were delegations coming to Islamabad, state leaders coming to visit the Pakistani leadership in Islamabad, you would typically sign a raft of agreements. Sports collaboration agreements, cultural collaboration agreements, memorandums of understanding, a raft of agreements that have no practical implications whatsoever, except for providing sort of diplomatic tokens of goodwill, photo ops, something for the press. And typically, in the case of Pakistan, it would throw an investment treaty in there, because it sounded nice. A typical investment treaty is 6 to 7 pages, very vague language that tells the parties that they should treat foreign investors fairly and equitably and not expropriate without compensation and so forth. But there was never an expectation throughout the bureaucracy that were negotiating these agreements, and I got in touch with many of them who had been negotiating since the 1980s, about 30 people in total, and they said, well, from their perspective, they were not considered to be relevant in investor-state disputes in practice. They were something that you sort of signed because that was the thing to do at the age of the Washington Consensus. And in the case of SGS versus Pakistan, it was so embarrassing that the Pakistani government had to ask the Swiss government formally for a copy of the treaty because they couldn't even find the treaty itself. Don't even get me started about negotiating histories. There was none of that whatsoever. Okay, so that of course may be Pakistan being dysfunctional Pakistan. Maybe that was just sort of a unique case in which it wouldn't be particularly interesting, except of course for the Pakistani bureaucracy who had to defend themselves in some of these claims. So what I did over the next 6 years was to try and assess, well, was there a general pattern here amongst, if not all developing countries, of course, because some of them knew exactly what they're doing, was there perhaps a large number of developing states that entered into these agreements in the same sort of fashion, haphazard fashion, that Pakistan had done? And to sort of cut to the chase, the main conclusion from the book, which is available online, was that a very large number of developing countries, including a large number of small developing countries, negotiated the agreements in a very similar fashion, ultimately misunderstanding the ultimate nature and the ultimate potency of these agreements, signing up to some of the most significant legal instruments underwriting economic globalization, in many cases without even realizing it at the time. Not until they were sued did they realize the potential liabilities involved. In another case, this was the case of South Africa, where I spent a couple of years to study that case. At one point, the South African government decided to delegate the negotiation of investment treaties to regional desk officers within the Foreign Office. So if you're on the Middle Eastern desk, you were allowed to go and sign investment treaties with Middle Eastern countries. If you're on the Latin American desk, you could just sign investment treaties with Latin American countries, and so on and so forth. So you had sort of an army of officials traveling around the world, none of which had any sort of appreciation of the nature of the beast that they were negotiating and signing. In one case, there was an agreement signed with Mali, where the foreign minister of South Africa went to Mali, came back, and after that visit, there was an investment treaty. It was submitted to ratification in the parliament, and the secretary in the parliament was very embarrassed, but he had to send it back because both Mali and South Africa had forgotten to even put the names of those two countries on the text itself. It was just a copy of the British template BIT that had been negotiated. Here we have some feedback from other developing countries. In the case of Croatia, this is a former negotiator. There were no cases against Croatia, so we didn't think they were that important. But after we were sued in 2004, we now understand the relevance and the power of these agreements. In the case of South Africa, we used to call them apple pie agreements. And it's not until we got sued we truly realized that we should have had our red flags up. In the case of Mexico, a former experienced negotiator said that during the 1990s, investment treaties were a very different animal than free trade agreements, the WTO, and other globalization instruments. Many here in Latin America thought it was harmless to sign these treaties. No one had an idea what they meant. They just signed them off within a few days, within a few hours. There was no legal review. There was no control. There was no scrutiny of the content. And no one cared until the dispute came. From the other side of the negotiating table, the feedback is the same thing. A very experienced negotiator from the Netherlands says, during the 1990s, developing countries often asked us what even basic provisions meant. So what does fair and equal treatment actually mean? Well, I can't even tell you that question, but basic provisions such as national treatment, expropriation provisions, and so on and so forth. Canada, in the past, we actually had to drop some negotiations simply because the level of understanding was lacking. In the case of Germany, we had the impression that they had very little knowledge about these agreements. But that didn't make negotiations easy, because then we had to explain everything. And let's see if I can see here. And then there were countries who just wanted to sign whatever the text, but these, of course, are extreme examples. Pakistan was one of them. In most cases, we were bombarded with questions. What does non-discrimination mean? What does free transfer mean? And in each negotiation, we had to explain it not just once, but many times. Some arbitrators have also noted that this is how they've often seen these treaties to have been adopted in practice. Not in every case. Many, as I said, many developing countries had very skilled lawyers, and I'll get back to that, who knew pretty much what they were doing. In some cases, they have even better teams than on the other side of the negotiating table, but the vast majority did not. And the outcome of that sort of haphazard process is this. Here we see on the y-axis the average number of investment treaties ratified, or bilateral investment treaties ratified over time. And on the x-axis, we have years before and after countries were subject to their first BIT claim. This is an average figure. And we see that the rush to sign and ratify bilateral investment treaties up through the 1990s, early 2000s stops, or at least slows down significantly once countries became subject to a claim against themselves. Not their neighbors, not other countries, but once they themselves became subject to a claim, that's when many developing country officials suddenly realized what they've been negotiating for the past many years. That doesn't mean that they've stopped signing investment treaties. That's something we can get back to. And also, one of the things that this graph doesn't show is that now investment treaties are increasingly enshrined into broader free trade agreements as investment chapters. But nevertheless, the nature of the negotiations have changed very significantly over the last 10, 15 years as governments have realized that these are not just diplomatic tokens of goodwill. They are, in fact, quite potent agreements. And if that's how South Africa negotiated the agreements, if that's how Pakistan negotiated them, Mexico in some cases, Ecuador, Argentina, Malaysia, Thailand, and so forth. If that's how the negotiations worked in large developing states, one can just imagine the sort of constraints on small developing states. Not all. So Jamaica is one case, for instance, where during the 1970s, 1980s, they had a very, very skilled negotiator. But in many other island states, there were significant challenges in terms of bureaucratic expertise. Now, what do you do when you don't have sufficient expertise? I think this might be something Dominic will get back to in his presentation as well. But of course, many get advice from the United Nations, from UNCTAD, from various legal consultants. But in many cases, and that's something I trace in the book, small developing states have also gone to arbitrators and arbitration practitioners to get advice. And in many cases, arbitration practitioners have been the core providers of legal advice in terms of whether you should sign investment treaties in the first place and how they should be drafted. And that, of course, raises a series of questions in terms of conflicts of interest when legal practitioners advise on legal products that in turn provide the market for their own legal services. Right? So in some cases, for instance, the American Bar Association sent some arbitration lawyers in the early 1990s to former communist states. And today, we have a couple of arbitrators that sit as arbitrators in cases on the basis of treaties they themselves encouraged those states to sign up to in the first place. So one of the suggestions that have been raised in recent years is whether or not it might be a good idea to have a similar center for advice as we have in the context of WTO that was just mentioned. According to me, I think that should also cover negotiations, but at least in terms of dispute settlement, that would be a useful contribution, particularly for small developing states. Now, even if you have the expertise, one of the challenges in many jurisdictions is that the bureaucratic structure, in particular former Commonwealth states, is such that you have these, this is a mundane point, but it's important, you have these rotation schemes within bureaucracies, which means that expertise is rarely institutionalized. It sticks with the individual. So anyone who's advised developing countries, or many developing countries, on investment treaty negotiations, many will tell you that it can be quite frustrating because you build up some level of expertise amongst core officials, and then you go back 3 to 4 years after, and then they're in the sports ministry or in the cultural ministry, and then you have to start all over. And that's a significant challenge, but it's of course one that can be dealt with. Finally, even if you have the expertise, even if you have the bureaucratic experience, in order to avoid disputes that the government, central government, would like to avoid, you of course need to implement your obligations. You need to inform local officials who deal with foreign investors on a daily basis exactly what these obligations entail. You have to have information sharing systems in place. Very few states, even large developing states, have that in place, which is part of the reason why we're seeing so many breaches of investment treaties happening on a monthly basis. That's it for now. Thank you.
Thank you very much, Lauge, especially for bringing the train into the station on time. That's always appreciated. It struck me looking at some of those quotes that you had there from developing states about their lack of appreciation of the significance of the obligations that they were undertaking in these treaties, that one could easily find similar statements from developed states, especially in Northern Europe, who only after having been on the receiving end of investment treaty claims have come to understand the significance of those obligations and are beginning to implement some of those lessons as they now negotiate as the European Union with states like Canada and Vietnam. Sometimes being on the sharp end of a litigation focuses the mind.